Good morning again. Hopefully we won't keep you until 10 after 10 today. I'm going to go ahead and get started. We've got some people that aren't here, but they did call and ask for an excuse. They did call and ask for an excuse. Some people haven't gotten that message yet. Mr. Wilkinson.
Fellow members of the committee, I'm bringing to you in House Bill 189. This is the dental insurance bill that we discussed yesterday. Bottom line, no contract or agreement between a dental insurer network and a dentist shall require the dentist to accept an amount for dental care services that are not covered dental services under a dental benefit plan. This is the bill that was recommended by the National Conference of Insurance Legislators. It's passed 16 states. It's being reviewed in 17 states as we speak in the legislative process. Basically what this is that dental insurance will cover cleanings, fillings, crowns, and so forth. They do not cover cosmetic services like teeth whitening. And what's been happening is the insurers have been telling the dentist what they have to charge for these cosmetic services, even though the dentists are not being reimbursed for this. The major dental insurers have either endorsed this or have said they wouldn't oppose it. There's just been one group that has not gone with it. Yesterday, Mr. Chairman, the majority leader spotted something that I missed. I thank him for doing so. And if I may invite your attention to lines 49 and 50, a violation of this code shall be punishable as an unfair trade practice under Article 1 of Chapter 6 of this title. That's not necessary. Obviously, the insurance commissioner would be involved, the insurance department, with any conflicts. We do not need the unfair trade practice in here. And so I have an amendment that I hope the committee will approve, which deletes all reference to that in lines 47 and 48. Be glad to answer any questions.
Do we have questions?
Thank you, Mr. Chairman.
Ms. Sims.
Thank you, Mr. Chairman and members of the committee. I bring back again, oh, pardon me, on second page, excuse me. Oh, it's 247, but I mean 249, sorry, did not see where it was located. It is a modified structure. It has to do with the rise of pertussis that are known as whooping cough. And we kind of thought this was gone, and it has come back again and is causing problems, and in some states has created a lot of deaths in children, especially infants. So this is simply a bill that will educate the parents who take home their children. The hospital will put an insert into the material when the parents leave the hospital, advising them of the threat of pertussis.
Mr. Whip.
Just a quick question, Representative, and I thank you for bringing the bill. Particularly given your district and the hospitals in your district, have you talked to the hospitals to see what their opinion is, or whether or not this is something that they think would be beneficial?
They're fine with this bill, Mr. Whip.
Thank you.
Never mind. Any other questions? Thank you, Ms. Sims.
Thank you.
Mr. Neal.
Thank you, Mr. Chairman. Coming back today to talk again about House Bill 265, I understand there might have been a little bit of concern about the process, and I wanted to make sure that we had that clear so that everybody understood what the process that we're looking at with House Bill 265. The council that we are looking to set up will be a council that will, throughout the course of the year, do a study on the criminal justice system, and they will bring a report to the Speaker, the Lieutenant Governor, the Governor, and the Chief Justice of the Supreme Court based on their findings. We are setting up also a joint committee of the House and Senate. Those committee members are outlined in the bill: President Pro Tem of the Senate, Speaker Pro Tem of the House, Majority and Minority Leader of the Senate, and Majority and Minority Leader of the House. Chairpersons of the Senate Judiciary, House Committee on Judiciary, House Committee on Judiciary Non-Civil, Chairpersons of the Senate State Institution and Property Committee and House Committee on State Institutions and Property, 3 members of the Senate appointed by LG, 3 members of the House appointed by the Speaker. During the session next year, the chairman of the joint committee, who is a member of the House of Representatives, and that would be Chairman Golick, the House Judy Non-Civil, will cause to be introduced to the House of Representatives 1 or more bills that incorporate the recommendations. There's nothing in this bill that says that we have to introduce specifically what they bring to us. That bill will then go to the committee and go through a committee process where there will be opportunities for amendments in the committee process. It'll then be debated on the House floor, and if passed, will go to the Senate, where it will again go to the special joint committee in the Senate. There'll be opportunities there as well to address any issues with those proposals and make any amendments. So this is not something similar to what we're dealing with right now with the Tax Council, which is required legislation introduced from a council with an up or down vote. This is legislation that will have the full attention of the House and Senate with plenty of opportunities for amendments and adjustments through that process.
Mr.
There's that one. Sorry. Chairman Neal, again, thank you for bringing this, and this is an issue that we're definitely going to be tackling next year. During some conversations yesterday, it was really more of a procedural issue that came up. And looking at the bill, and we had looked at this in the committee process, and I think we had come to a conclusion on it. There were more conversations that have occurred. After it comes out, it's going to be referred, according to the legislation, to the joint committee. Then it goes to the House. The House will then, take action. If the House were to go ahead and pass 1 or more measures, it's not clear from what the bill says. It would go to consideration by the Senate. What's not clear in the legislation is that would it go through a Senate committee? Would it go through the joint committee again, which would be a little bit of a hybrid, of course, than what we're used to. It will have already gone through the joint committee, then go to the House. If something's passed out by the House, then the question is, would it go back to the joint committee or directly to the Senate, or directly to the floor of the Senate? According to the bill, it really would go to the Senate as opposed to going back into the joint committee. Is that your take on it as well?
It'll go back to the Senate, line 79, go back to the Senate, and will be referred by the President of the Senate only to the joint committee. So it'll go back to that joint committee again in the Senate for additional work if there are any other issues that need to be addressed in that process.
And here's the issue that came up, and I appreciate your saying that. It struck some a little odd that it would go to the joint committee, then go to the House floor, and then the Lieutenant Governor would refer it back to the joint committee from where it already was once. That's obviously something that we're not used to, the process we're not used to having here, but upon further reflection, I think there is a thought that maybe that's a good thing, that it'll go back a second time. Issues that may have come up in the past, that didn't come up, but came up after the fact, could be addressed again by the joint committee, sort of a second bite at the apple. So
absolutely,
it's not conventional by any means, but by the same token, out of an abundance of caution, given the subject matter that we're talking about, and obviously from a substantive standpoint, is a big ticket item.
Mm-hmm. Absolutely.
That may be the way to go. And I think that procedural dynamic threw some people a little bit. But what you're saying, I think I hear you saying, is that it's not necessarily a bad thing to go back a second time to clean up any issues that frankly we may not have caught on this side. Now, of course, that's not going to happen. But on the extreme off chance that there's an issue that comes up,
just in case the unusual happens.
There you go.
Thank you, Mr. Chairman. And I do have just a point of order. Is it not true that for 3 years we had the statewide Water Planning Council, and we deliberated there and presented we presented actually a resolution to the House that was adopted, and the process was to go back and forth between the Water Council and the General Assembly to perfect the language because so many different groups were working on it, and they were charged with doing that. So we do have a precedent, although not through judiciary, but through natural resources.
Now this doesn't go back and forth to the council. Once the council makes a report and delivers that report, it is then the joint committee of the House and the Senate that will be handling it from there. The council will do the study and make the report, deliver it to us, and then they're out of the picture while we make the deliberations on what we believe we need to do moving forward.
Thank you.
So, Representative Neal, where's the General Assembly in this process? Do we weigh in at any point on this?
Absolutely. There'll be 3 members of the House and 3 members of the Senate that will be part of the council. And when the council brings the report, the joint committee that's made up of members of the House and Senate will take the legislation that's introduced, will bring a bill to the floor of the House, and the House will have the opportunity with these bills or resolutions, like with any bills or resolutions that come before the House, to take action on them, whether it's through just voting yes or no, or whether there's amendments along the way that are a part of it as well. It will once a bill resolution is passed by the House, it'll go to the Senate and go back through the process again. So the General Assembly will have every opportunity to be involved with these pieces of legislation as with any legislation that comes before the body.
I think it's good to talk about it.
Any other questions? Thank you, Mr. Neal.
Thank you, Mr. Chairman. Appreciate it.
Mr. Chokas.
Thank you, Mr. Chairman and members of the committee. I'm back in the hot seat, and I'm requesting 2 bills, HB 156, which is structured rule, and HB 290, which is a modified structure, both on the second page. HB 156, as I brought forth to y'all yesterday, will add state highway employees to the indemnification program and death benefit that currently is enjoyed by the law enforcement officers, firefighters, emergency medical technicians, emergency management rescue specialists, and prison guards. And to answer Chairman Willard's questions yesterday, I got from the Georgia State Indemnification Program, the Department of Administrative Services, a definition of a state highway employee and the definition of in the line of duty. And a state highway employee, and I'll read this to you if it's okay, who is a Department of Transportation employee who receives compensation directly and regularly engages in the duties necessary for the construction, maintenance, and operation of roadways within the public roads of the state. Now, within the line of duty, as defined by DOAS, with respect to the state highway employee, while on duty or performing any work necessary for the construction, maintenance, and operation of a roadway on or within the public roads of the state, when such employee is killed or permanently disabled as a result of working under hazardous conditions in close proximity to moving traffic and equipment. Such terms shall not mean commuting to and from work or commuting to and from training. So I think that would more clearly define what the purpose of this bill is. Those employees are working under hazardous conditions with traffic moving by rapidly, and that is the reason for this legislation. I'll be happy to answer questions on HB 156 right now, or I can move on to HB 290.
Mr. Whip.
Bottom line is we're taking care of our high risk safety.
Yes, sir.
Thank you. That's all.
Thank you.
I think that's how we can sort of boil that down.
Good.
Do 290.
Thank you. HB 290 is the P-card legislation that I brought forth before y'all yesterday. Basically, what this legislation does is currently state law does not explicitly require authorities to adhere to the P-card requirements set forth by the DOAS. As y'all recall, a couple of years ago, we had some scandals dealing with the improper use of purchase cards, tape purchase cards, and unfortunately at that time when the legislation was written, we left off authorities, and the authorities that we would be adding in this legislation would be like the Ports Authority, the World Congress Center, and so forth, and I think it's necessary for us to be fiscally responsible.
Any questions? Thank you, Mr. Chokas.
Thank you, Mr. Chairman and members of the committee.
Matt, before you start, Mr. Doorkeeper, would you look out there and see if Mr. Kidd he was in here and wanted to do one? He's not out there? Okay. Matt, let Mr. Amerson go first. Yours might take more than a minute.
Thank you, Mr. Chairman. I hope this is short, sweet, and to the point.
So do we.
I'm asking for House Bill 224, is found on the front page under modified open rules. The bill defines off-road vehicles. It solves two problems that we've had in the state, and at the top of page 2, you see one of those. That is that a vehicle operating on state-owned, managed, or controlled property will have a tag. This was vetted through DNR, and that was their desire. The second part is subparagraph B, and that means that anyone else who chooses to have their vehicle registered and tagged may do so. The price of the tag will not exceed $30, and it will be for the life of the vehicle. It does not have to be registered or tagged any other time after the first time. If there are any questions, I'll be very happy to answer them.
Mr. Earhart.
Thank you, Mr. Chairman. Representative Amerson, let me make sure.
I'm trying to find, I recognize the voice. Thank you.
Right here, sir. Let me make sure I understand this. So if I want to operate my four-wheeler in any area that may or may not be determined to be I think the definition was a state-owned property, large tracts of Georgia, parks and those types of things, I'm going to have to pay a tax of $30. Is that correct?
Up to $30. It'll be up to the Department of Revenue to decide the price. Yes, sir.
So in that case, it is a tax if I want to operate that vehicle like that. And if I don't, it's a $300 fine?
If you don't, that's the only place that a fine would occur, and yes, it could be up to $300. And what we have is a situation within the wildlife management areas and some of the others where people are driving their vehicles through there and DNR can't keep track of them.
Okay, so are all of these areas, what is the responsibility of the department to mark these areas? If I'm utilizing this in a farm next to one of these areas and I stray over into that area, does that area have to be, these are trails in the woods, and I can be fined by a DNR agent for not having a tag on my four-wheeler?
Well, I wouldn't think they would go quite that far, but there are a number of people who pull into wildlife management areas and park areas, and I understand what you're saying, but there is no requirement, as long as you're on non-state-owned property, to have a tag.
Roberts.
Thank you, Mr. Chairman. Chairman Amerson, simply what you're trying to get at is you're trying to have a program to set up for registration for ATVs so that if anyone goes outside the state, currently right now there is no system set up and some of your constituents are having issues when they go to Tennessee and other states because they don't have any registration nor do they have a method by doing it. You're just trying to set up a system and then it was DNR that come and asked about the state parks, correct?
That's correct. North Carolina, South Carolina have tags, and some of our people go over there for participating in rodeos, and they have been fined because their vehicles had no tags.
Thank you.
Ms. Drenner.
Thank you, Mr. Chairman. I understand the intent of this particular piece of legislation, but I was under the distinct impression that you were not allowed to go on parks and ride ATVs. That was my impression all along, that was prohibited. Did we change that somewhere along the way?
No, that's in the control of DNR, and they allow people to travel in off-road vehicles all the time.
Mr. Rice.
Thank you, Mr. Chairman. It's not true, Representative Amerson, Chairman Amerson, that this will aid the DNR park rangers in being able to identify people who are effectively illegally going off-road into these woods. And the DNR park rangers put their lives at risk trying to trace these people down. There's no means to identify them unless they're in effective reach of being able to apprehend them.
Thank you, Chairman Rice. Yes, that's absolutely true, and that's the reason they're included in here.
And wouldn't it be also helpful for people who might have their vehicles stolen from the side of the road if they're tagged?
Other people have jumped in on this. You're right, sir.
Mr. Weldon.
Thank you, Mr. Chairman. Chairman Amerson, from what I understand from discussion here, you have a problem with some of your constituents that are going out of state, and they're having problems in out-of-state situations because there's not a registration system.
That's true, and that's the reason this is all voluntary except for vehicles traveling on state-owned property.
Now, and also one of the benefits of this proposed bill is that it'll aid DNR rangers in identifying people.
Yes.
And the reason we need this is we can see them, or the rangers can see them from afar and identify the registration, identify the person.
Yes, they can keep track of the vehicles traveling through.
Don't we already have a problem with these photo intersections where they're photographing a license plate and then they're sending a ticket to someone who may or may not be driving the vehicle?
That's beyond the scope of this bill and beyond the scope of my knowledge.
Mr. Chairman, one more question. But doesn't DNR have the ability to chase those people down on the vehicles we provide the DNR rangers and identify them that way?
Well, they may or may not, but as Chairman Rice just brought up, they put their lives in danger each time they try to run someone down who's out there shooting deer or hogs or whatever they're trying to hunt.
And then that's their job, right?
It's their job, and we're trying to help them out.
Thanks, sir.
Mr. Setzler.
This is a simple bill.
Thank you, Mr. Chairman. I just...
Surprise.
I just wanted a clarification. The state of the law today is, just clarifying, that in wildlife management areas, someone can ride an ATV in Georgia without a license. Is that correct?
Without a registration or tag, yes, sir.
And the effect of this bill is for people in Georgia in wildlife management areas, it would now require them to have a license to ride on marked trails in wildlife management areas.
That's correct.
Okay. You had mentioned some things about other states, but the effect within the state is it requires licensure for ATVs, as I understand. Okay. I just wanted to clarify that, sir.
Thank you. Mr. Secretary.
Representative Amerson, I was just looking on line 16. looks like it includes go-karts as well. Was that intended?
Tag a go-kart? It's a go-kart, yes, sir. And as long as it's on private property, there's no requirement for a tag.
Okay. Thank you, Mr. Amerson.
Thank you, sir.
Mr. Kidd, do you... You can if you want to. Greg?
Explain House Bill 74 briefly. It does not have a fiscal note, doesn't require any money. It says when funds will be made available for students who enroll at GMC in Milledgeville and commit to the armed services after graduation and so forth, sign a contract for the armed services, would be able to draw down an equal amount of stipend money as do currently the students up at North Georgia College. It says when funds are made available, so in the future time, when the state has some extra funds, they might appropriate it for those students.
Thank you. Nobody hit the button. Did Matt leave? He gave up. Mr. Ramsey.
Thank you, Mr. Chairman. I come today to ask for, on the first page under modified structure, House Bill 87, the Illegal Immigration Reform and Enforcement Act of 2011. And I will proceed at the chairman's pleasure. There's been a great deal of talk and a great deal of information available in the public domain about this bill. It's a lengthy bill. I'm happy to go through it and summarize it, or I can just simply yield for questions from the members of the committee at the chairman's pleasure.
Just yield for questions.
Okay.
The minority leader.
Thank you, Mr. Chairman. Mr. Ramsey, I'm going to refer to sections 2, 4, and 5 in the bill. Is it not true that this legislation will allow any legal resident of Georgia or groups of residents to file multiple simultaneous claims against any local government, whether they live in that jurisdiction or not, for alleged violations of this act?
It would give standing to any citizen of the state of Georgia. And I think to put my answer in context, I think it'd be helpful to discuss the genesis of those sections. In 2006, the General Assembly passed Senate Bill 529, which was put in place to provide a bar for those that are in the country illegally from receiving taxpayer-funded benefits. Two of the key cornerstone provisions of that bill was a requirement that state and local governments enroll in the federal SAVE program, which verifies eligibility to receive benefits, and the requirement that state and local government at the point of receiving an application for a public works contract get an affidavit from the contractor that they're enrolled in E-Verify. The hole in that law was that the legislature didn't put any enforcement mechanism or any penalty for not complying with that law. So we have found over the last 4 years, while well-intentioned, it's not being complied with. And in fact, many governments haven't even bothered to enroll in SAVE, a basic requirement of the law. What we've done here is provide citizens the ability to seek injunctive relief if your local government or a state agency is not enrolled in SAVE or is not following through on the requirement to collect E-Verify affidavits from contractors at the point of a public works contract application. What we've done in the section, and they can't file litigation until they provide notice. We have provided a kind of a front-end cure period whereby if I believe a government is not compliant with the requirement to enroll in SAVE or the requirement to collect E-Verify affidavits, I then have to give notice to that government and provide specificity as to what I'm alleging they are not complying with. That government then has 30 days before litigation can go forward to get in compliance. And this is not a difficult concept. Either you're not enrolled in SAVE or you're not. Either you're collecting E-Verify affidavits or you're not. I think that builds that safeguard in. We've added an additional safeguard in that says even if the litigation goes forward, so the claimant brings a claim, and the government, whether it be a state agency or a local government, believes it is a meritless claim and they file a motion to dismiss, that then stops the clock on the litigation. So there's not costs being incurred until the judge rules on that motion on the pleading. So we believe there's adequate safeguards in place, but this is a key piece of the bill. We've got government agencies that are not complying with the law of the state that's been in place for 4 years, and we just simply can't continue to acquiesce to that, given the fact that it's our taxpayers that are footing the bill for it.
A further question. Is it not true, though, that I do not have to be a legal resident of the jurisdiction where I'm filing the suit? So someone in Gwinnett County can file a suit against someone in Osceola without having
Absolutely. You have to be a resident of this state.
A further question, is it not further true that failure, you just explained the process, but that 30-day window, if they fail to investigate each claim, and the language of the bill actually refers to not only compliance with registering for these programs, but that you comply with all rules and regulations related thereto, so that I could file, or I could pull together a group, we could file multiple and simultaneous claims, and a local jurisdiction would be obligated to investigate each and every claim because they face the punishment or the injunctive penalty of up to a $5,000 fine for each claim that could be filed against them. Is that not correct?
Absolutely, but you have to, in giving notice, state with specificity what allegation you are alleging is occurring. And again, this is not a very difficult concept to get in compliance with. Again, either you're enrolled in SAVE or you're not. Either you're collecting E-Verify affidavits from contractors or you're not. The easiest way to avoid potential litigation after all these safeguards that we've put in place is to comply with the law that's been the law of this state for 4 years.
One further question. Is it not true then, I'm a small business owner in Fulton County. I file my E-Verify application, but I have colleagues who receive the request from local governments but do not file. Under the terms of this legislation, the failure of the local government to pursue me and guarantee that I return those filings, whether I have knowledge or not of a business that may or may not have registered, an individual or group of individuals have the ability to file suit. They have the ability to claim and to aggregate as many claims as they would like. They don't have to live in the jurisdiction. The local government has the obligation to investigate each and every claim in order to forestall litigation against them, meaning they have to use their own personnel hours to investigate each of these businesses to ensure that they are in compliance. And then in addition to that, there is no penalty for anyone who files these false claims. So I can file thousands of false claims, require local governments to investigate, and there's absolutely no impediment to me doing so because there's no penalty in here for false filings. Is that not true?
Well, if I understand the premise of your question, first, a government is not obligated to investigate a business. And the government is obligated to, at the time a business applies for a public works contract, get an affidavit that says they're enrolled in E-Verify. There is nothing in the current law or this law that requires a government to go out and investigate a business. All the requirement is simply this. When you put in your application, part of that application has to be an affidavit that you are enrolled in E-Verify. If you bring a frivolous lawsuit, as the gentlelady well knows, there are absolutely sanctions in our Civil Practice Act for bringing meritless claims.
I was not asking about the lawsuit. My question goes to the filing of the notice. The notice does not necessarily lead to litigation, but the investigation requirement for local government precedes the actual filing of a claim. So it would strike me that the filing of the notice by the individuals, which may not necessarily lead to litigation, could require and in fact does trigger that 30-day investigatory period by the local governments, and that's the period that I'm concerned about because there's no impediment to any person who does not live in that jurisdiction from filing multiple and simultaneous claims against any local government.
There is no requirement that a government investigate in that 30 days. This is an opportunity for the government to have notice in case there is merit to the claim that they're not in compliance. If I serve what is a frivolous notice, a frivolous claim in that 30-day period, I have the option of that government to simply ignore it. And then if they bring a lawsuit, you file a motion on the pleadings, which, as you know, as an attorney, is a way to test the sufficiency of the pleadings to see if the litigation can go forward. There's no obligation they investigate. This is to give them an opportunity to demonstrate they're in compliance. And if it's frivolous and meritless, they have the option to ignore it.
Thank you.
Mr. Cassis.
Thank you, Mr. Chairman. Representative Ramsey, I do commend you. I mean, this bill finally has some provisions that we certainly needed in the state of Georgia, especially Section 7. We're finally doing I guess, what is it, the identity fraud on, or identity theft on those frauds. So I think that's an important section. But my concern comes in Section 10. If you look on page 11 and page 12, now, on the provisions are harboring, the application of that definition under subsection B, I'm okay with, because it says the person has to be acting in violation of another criminal offense. So far right now, preaching the gospel and providing food and shelter is not a criminal offense yet in the state of Georgia.
That's exactly right.
However, on page 11, in your definition of harboring, it does say that any conduct that tends to substantially help an illegal alien to remain in the United States and it's in violation of federal law will be considered harboring. Now, you have exceptions there, but it does not include preaching the gospel or providing food and medicine. There's Must Ministries, there's Food Pantry, there's a lot of benevolent efforts that are being done by parachurch and church organizations. And the way I understand it, there would be in violation of this definition.
Well, you have to read that. You have to read that in the context of the limitations that we put in place. I mean, that's simply a definition to provide additional guidance to the prosecutor and the court in determining whether the act rises to meet the crime, which is knowingly harboring an illegal alien. You have to still be have to be proven to know that you know the person that is an illegal alien. You have to prove that they're committing another crime simultaneous with that, and you have to prove they're doing it for the purpose of helping them that the conduct substantially helps them to remain in the country illegally. This harboring definition is a definition that has been developed by courts in other jurisdictions, federal circuits, to define what harboring means. The federal statute didn't have a definition of harboring originally. We pulled that definition in, and to my knowledge, where these prosecutions are brought, there has never been a prosecution against a welfare provider or a church ministering to its parishioners.
Okay.
Ms. Hughley.
Thank you, Mr. Chairman. To the author of the bill, I'd like to go back to Sections 7 and 8. In this new offense of aggravated identity fraud, when people are trying to secure employment, did you consider the possibility that battered women, when they're in trying to get away from a difficult situation, they may have to secure employment by using a name that is not theirs in order to be protected in that particular situation? Did you mean for this to apply to them as well?
No, and I don't believe it does. You have to willfully and fraudulently use counterfeit or fictitious identifying information concerning the identity of a real person, a fictitious person, or a deceased person for the purpose of obtaining employment. That is a huge problem in this state, and it's jeopardizing our employers from a legal liability standpoint, because what is happening over and over and over again is people are passing false identification documents, and then ultimately if there's a raid on that facility, if it's a plant, and they are ultimately identified to have a one or a group of individuals that are in this country illegally working for them in violation of federal law, the employer is put in the difficult position of having to explain why that is, because it is a federal crime to knowingly employ a person that is not in the country legally. I don't believe the way this is drafted in any way would rise to the level of being able to prosecute a person that is trying to obtain employment using a new identity resulting from as a victim of crime. But so I don't think it applies in the scenario that you laid out.
So what about this word fictitious that you have in here? That doesn't apply?
Well, certainly it applies. This is a very tightly drawn provision, that is aimed at getting at exactly the conduct that I described to you that is happening every single day in Georgia. The 100% root cause of illegal immigration in this country is illegal employment. Every single time a person obtains a job using fraudulent identification, A, you're perpetrating a fraud on the employer, and B, you're taking it a step further, you're putting that employer in legal jeopardy. And that's a practice that we just can't sanction in this state.
One further question then. If we don't want illegals to work here, why would we want to take care of them for 15 years at taxpayer expense in our prisons?
Well, certainly in conjunction with the federal government, ICE right now is prioritizing felons in terms of determining who to deport from the state and local criminal jurisprudence system. This is likely a crime if the commitment, if the offense was proven, that there's a very likely, a high likelihood that ICE would place a detainer on that suspect and they would be deported. But certainly if they commit the crime and ICE is not going to take them off their hands, I would much rather them be in our correctional institutions than trying to perpetrate another fraud on the employers of Georgia.
Let me interrupt here. It is the responsibility of the Rules Committee to set a calendar. We're not here to have a full-fledged debate or hearing on the bill. You'll get that opportunity when we set the calendar. Ask questions. Ms. Drenner.
Well, after what you said, I'm not sure if I should ask a question or not. So I'm kind of confused. If I just
ask a question.
Okay. Thank you, Mr. Chairman, and Representative. I want to draw attention to Section 11, line 431, and my question has to do with what specifically probable cause is for pulling someone over. Can you please explain that? Because it seems like there's an aspect of profiling that may be involved in that particular language.
Probable. The way this is set up is this is the section which gives a law enforcement officer the ability to do immigration status checks in connection with some criminal investigations. But before that process can even begin, you have to have probable cause to believe that a criminal suspect has committed a criminal violation. Probable cause is perhaps the most heavily litigated concept in the criminal code. It is a concept that is a predicate that an officer has to have before they investigate any crime, whether it's a person that's driving recklessly or whether it's a person that's allegedly committed murder. That's the predicate before whatever the act is, before this process begins that ultimately could end up as part of trying to identify the suspect, by which the officer can do an immigration status check.
Mr. Weldon, did you? Ms. Abrams.
Mr. Chairman, at the appropriate time, I can either direct this question to you or to the author. My concern under Section 7 is that while I think the author intended his answer, I'm not certain the language of Section 7 does address the fact pattern that was introduced by my colleague, and my concern is that if this moves forward under modified structure, my question is what's the posture of this committee to ensuring that we do not unintentionally capture women who are using fictitious identities while they're awaiting permanent action by the state or by the federal government, because typically that process can take up to 6 to 12 months, and in that interim period they may use fictitious identities in order to escape their batterers and to secure employment, and there is no safe harbor under this current legislation that would allow that to happen while they're awaiting those new papers to be processed.
That'll be directed to the author.
I disagree that could occur. We've worked very closely throughout this entire process with the advocates for victims of domestic violence and made numerous changes in the bill. This has never been raised as an issue. I don't believe it to be an issue, but certainly would work with you once we get it out of the House and over to the Senate to potentially tighten that language. If you think I don't believe it's necessary, but but I'll certainly look at any language that you would suggest as we move this bill over to the Senate.
With one further question, can you show me where in the language there is that safe harbor? Because right now the plain language says any real, fictitious, or deceased person using that identity. I don't see where there is a safe harbor that excludes the purpose for which the identity is secured other than the requirement that it's being used to obtain employment. And so if I'm a battered woman who uses a false driver's license to get employment, there is no safe harbor in this language that says that I can't be prosecuted.
The purpose of this is to prevent a fraud being perpetrated on employers. That's exactly what it does. So any individual that's perpetrating a fraud on an employer would potentially come under the strictures
So there is no safe harbor
of the bill.
Okay, so just to be clear, there is no safe harbor for the fact pattern that my colleague described under the plain reading of this legislation.
I don't believe a safe harbor is necessary because I don't believe that the necessary elements of proof could be made in that fact pattern to result in a prosecution under this provision.
Thank you, Mr. Ramsey.
Am I done?
You done.
Thank you, Mr. Chairman. Oh, Mr. Chairman, can I mention an amendment I have on this bill? If I could get everyone to turn to line 639. This is truly a Scribner's error. In the second to the last round of revisions to this bill, there was an effort to correct a typo on 639. In correcting that typo, a Scribner's error was made that on 639 it's supposed to read with 5 or more employees. The amendment that Chairman Roberts is going to offer will fix that. So my amendment would be withdrawn if Chairman Roberts' amendment is ultimately adopted. But if for whatever reason Chairman Roberts' amendment is not adopted, I wanted to have this in the queue behind it so we could correct that what is just a typographical error.
Okay.
So, thank you.
Members, Mr. Beard.
Thank you, Mr. Chairman. Just bringing back House Bill 262, that's the 1% increase on the judicial qualifying fee to assist funding the JQC.
Any questions? Mr. Chanel.
Thank you, Mr. Chairman. I'm again asking for House Bill 214, which completes the reorg of the old Department of Human Resources that we began last year. Mr. Chairman and members of the Committee, the Public Health in this current form is plain and simple in a mess. And what this bill does is provides the vehicle for the governor of this state to provide vision and direction for the Department of Public Health by extracting it from DCH and making a standalone agency. Mr. Chairman, at the request of Ryan Teague, who is the governor's legal counsel, I am offering an amendment, AM 33-1006, which is strictly technical in nature, doesn't have anything to do with any of the policy, but it requests the governor's legal counsel. I'm offering that as an amendment to follow the bill to the floor, Mr. Chairman.
Are there any questions to Mr. Chanel? Thank you. Mr. Willard.
I just want to bring to the chairman's attention when ready, there's 3 bills that we have dealing with code correction, 142, 143, 144 under modified structure. These are annual bills we do to find errors of codes that need to be corrected.
Thank you. Mr. Rice.
Thank you, Mr. Chairman. I'd just like to ask for House Bill 198 extends the sunset on the fees to support the statewide uniform automated information system used by the Superior Court clerks in recording of deeds and things like that. Extends it 2 years. Also, I'd like to ask for Mr. Amoson's HB 24.
Mr. Cassis.
Thank you, Mr. Chairman. I'd like to ask for House Bill 175. This is called the Online Clearinghouse Act, and what this act provides is for school systems to put their courses on a